intention to plead guilty today to count one, receiving and concealing stolen property of $1,000 or more, but less than $20,000.
Yes, Your Honor.
You understand that the maximum penalty for that offense is up to 5 years in prison and or a fine of $10,000 or 3 times the value of the property, whichever is greater.
Yes, Your Honor.
Is it also your intention to plead guilty to count two, fleeing a police officer, 3rd degree?
Yes, Your Honor.
You understand the maximum penalty for that offense is up to 5 years in prison or $1,000 fine.
Yes, sir.
Is also your intention to plead guilty today to operating with a suspended, revoked, or denied driver's license?
Yes, sir.
You understand that the maximum penalty for that is up to 93 days in jail and or a $500 fine?
Yes.
And is also your intention to plead guilty today to unlawful use of a motor vehicle operating without a license, plate, or registration or title?
Yes, Your Honor.
You understand the maximum penalty for that is up to 90 days in jail and or a $100 fine?
Yes.
Are you satisfied with Mr. Osment and the advice that he's given you?
Yes, I am, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Muir?
That's correct.
Mr. Osment?
Yes, sir.
Is that also your understanding, Mr. Zola?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Zola, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes,
You
Your Honor.
understand
I understand all
Okay.
these rights.
Okay, do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights, Mr. Zola?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead then to the charge that on or about August 29, 2022 in Ridgeway Township, Lenawee County, Michigan, that you did commit the offense of receiving and concealing stolen property of $1,000 or more, but less than $20,000?
Guilty, Your Honor.
How do you wish to plead to the charge that on or about August 29, 2022 in Ridgeway Township, Lenawee County, Michigan, that you did commit the offense of 3rd degree fleeing a police officer?
Guilty.
And how do you wish to plead to the charge that on or about August 29, 2022 in Ridgeway Township, Lenawee County, Michigan, that you did commit the offense of operating with a suspended, revoked, or denied license?
Guilty, Your Honor.
And how do you wish to plead to the charge that on or about August 29, 2022 in Ridgeway Township, Lenawee County, Michigan, that you did commit the offense of unlawful use of a motor vehicle without a license plate, registration, or title?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
Do you understand that if I accept those pleas, you're giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Zola to plead guilty?
No, Your Honor.
No, Your Honor.
All right, Mr. Zola, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty today?
Yes, Your Honor.
All right, Mr. Osmond, if you would like to cover the factual basis, you can do that now.
Mr. Zola, is it true that you were operating a vehicle in Conway County at the date and time the judge stated on the record?
Yes, I was.
And at that time, that vehicle was stolen and you knew it to be stolen property, correct?
That is correct.
And sometime during your driving, you were attempted to be pulled over by a police officer, Trooper Lulu Ganem, correct?
Correct.
And you failed to stop. In fact, you accelerated and then stopped and jumped out of the vehicle and ran, correct?
That is correct.
And during that time, your operator's license was suspended or revoked, correct?
Correct.
And is it also true that on that stolen vehicle, you took one of your other license plates, not for that vehicle, and put it on that vehicle to appear as a legitimate license plate, correct?
That's correct.
I have nothing further, Your Honor.
All right, Ms. Muir, any questions from people?
I do, Your Honor. I think we missed a couple things. One being, Mr. Zola, what type of vehicle was it?
It was a pickup truck, white.
So, okay, and do you agree that the value was at least $1,000, but less than 20,000?
Yes.
Okay, and when you saw that police officer, do you have any reason to object to that it was Trooper Lulu Ganem of the Michigan State Police?
Yeah, I knew it was a police officer.
And did they turn on their lights and siren?
Yes, they did.
Okay. And did you in fact increase the speed of your vehicle at one point?
Yeah. Yes, I did.
All right, Your Honor, I'm satisfied with the factual basis.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
Mr. Osmond?
Yes, Your Honor.
I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Zola has had full knowledge of his rights and he has had competent counsel. Court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for pre-sentence investigation, and we will set sentencing for March 24th at 8:15 a.m. Mr. Zola, someone from the Glenway County Probation Department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, Your Honor.
All right, Ms. Holly, do you need any additional information from Mr. Zola?
Where is he at right now?
Engler.
I'm at RGNC.
Oh, what got dismissed? Something got dismissed, but I didn't hear what it was.
Habitual offender, 4th.
Okay. Thank you. Nope, that's it.
Okay, all right then, Mr. Zola, you can let the officer that's with you know that you're done with our court for today.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you. Ms. Underwood, ready to proceed with Mr. Moore?
Yes, Your Honor. Thank you.
Okay, so we are on the record now in the People of the State of Michigan versus Anthony Harris Moore. File number 20-19796-FH. Today is the date set for a hearing regarding probation violation. We are proceeding today by video conference. First, let me ask Ms. Underwood to place her appearance on the record.
Rhonda Underwood for Mr. Moore this morning, Your Honor. Thank you.
All right, and Mr. Moore is present from the Glenway County Jail this morning. Ms. Underwood, do you know how Mr. Moore wants to proceed today?
Your Honor, at this time, Mr. Moore's case downstairs has a court date of the 16th So we would be asking to put this out past that, Your Honor.
And I apologize, we've got two cases here. One is 20-19796-FH and the other is 20-19849-FH. I think I read both of those numbers. So the 16th, we would be looking then at a pretrial. We'll do February 22nd at 8:15.
Thank you, Your Honor.
All right, Mr. Moore, you can let the officer that's with you know that you are done in court for today.
All right, thank you. Have a good day.
The gentleman at the MDOC facility that I just brought in the meeting, can you tell me your name, please?
Juan Cortez. Can you hear me?
Yes. Ms.
That
Underwood,
is
you need
my
a breakout-
client, Your Honor.
Do you need a breakout session with Mr. Cortez?
Just briefly, yes, thank you.
Okay, Mr. Murphy, we have Mr. Gritzmaker here. Are you gonna need a breakout session with him?
Please, Your Honor.
Mr. Gritzmaker, I'm gonna place you in a breakout session with Mr. Murphy.
Okay, thank you.
All right, Ms. Mull, you are here for Candace Seavey. Ms. Mull, can you hear me?
Sorry, Your Honor. Hi. I apologize. I had to back to the screen. Jolie Mull with Candace Seavey, P65500. Thank you, Your Honor.
All right, let me bring you Ms. Seavey in. All right, we are on the record now in the People of the State of Michigan versus Candace Marie Seavey. It is file 22-21073-FH. Today's date set for a final pretrial hearing. We're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
B. Mayor, on behalf of the people.
Good morning, Your Honor. Jolie Mull with Candace Seavey Defense.
All right, and where do we stand with Ms. Seavey's case today?
Your Honor, we understood certain terms were going to be part of a a plea. It seems there's some confusion, and Ms. CV is not currently willing to accept the plea as negotiated. I respectfully ask for an adjournment or a few moments for the prosecutor and I to resolve the issue.
Your Honor, the only holdup here is Ms. CV is on probation in Hillsdale and wants her probation transferred. And I indicated that that was a matter for the court to decide, not for me, which obviously I have no objection to that because she shouldn't have 2 probations. I don't know if the court can shed light on how that actually works. So to make sure it makes sense, because it's not like anyone would not want to transfer it if she's already on probation there. I'm just not sure exactly how that works. And I don't know that that's an agreement I can make. So if the court's able to explain how that works. Or some
I don't,
probation.
yeah, I don't typically play a role in that. That just happens through NPOC. I can't recall a time when I've ever been asked to approve that, although
Yeah, and that's kind of what I said too. It's
I certainly would have no objection to that. I think that Ms. Holly, are you there? Are you able to shed any light on
how that
the
works,
issue
just basically
of
because we don't,
transferring?
yeah, we've never had to do that before, so we
Wait,
don't
I
know.
missed everything. What are you trying to
So-
do?
So Ms. Seavey is currently on parole in Hillsdale County.
Probation.
There is an
Probation, not
agreement.
parole, but yeah.
I'm sorry, probation. She's on probation in Hillsdale County. She wants to enter a plea today if she can have her probation, in this case, transferred to Hillsdale County so that she only has one place that she has probation to deal with. Is that?
It's policy that we transfer the case to wherever they're living. So
Okay.
any violation or anything that would happen on this case would come back to Lenawee County. And she has to report to Lenawee County before it gets transferred.
Okay, so she would have to report one time here in Lenawee County.
At least, yeah, until they accept it.
And then
Okay,
it would be a
so
matter of Hillsdale accepting it. And then if she were to be accused of a violation, that would come back through Lenawee County as opposed to being dealt with by a judge over in Hillsdale.
Correct. Lenawee County always control over this. Yes.
Okay, all right.
So as long as she lives there, it sounds like it's not an issue, Ms. Small. So I don't know if you want
Right.
to
As
talk
long
to
as they can
Candace
verify
about
she's
it.
living there. Yep.
I
Can I
guess
still break up with my attorney, please?
my understanding, I'm sorry, hold on one moment, Ken. My understanding, what's your name? The person who spoke on the procedure?
Holly.
Holly? Our whole idea was that there would be no jurisdiction over her. And so that understanding, we respectfully just asked the prosecutor to give her time served at this point, as she's done 40 days. You know, we can revisit the whole issue and go back to negotiation if not.
If she doesn't get probation here, then there wouldn't be anything to talk about.
Yeah. Okay, well, I guess we need another pretrial then. I thought that would resolve the issue. My apologies.
All right, so today was actually a trial date that we converted to a final pretrial because, you know, that would only happen if someone called and told us that we had a plea agreement worked out.
And I think we did up until about 4 minutes ago, so I'm sorry about that.
Ms. CV has asked to speak with me in a breakout room. That might help, Your Honor. If we could have a few moments briefly in a breakout room, that would be great.
Hmm.
Or to be read.
Okay. Thank you so much.
All right, yeah, thank you.
Okay, Ms. Underwood, are you ready to proceed with Mr. Cortez?
Your Honor, does the court have time for a brief Cobb's discussion?
Not right now. I've got a very full docket this morning.
Okay,
And I would say the prosecutor also is Mr. Sneed, so it may have to be set with Mr. Sneed on a non-Wednesday morning.
okay. Let me just have another brief moment with my client if I could.
All right, 1 second. Mr. Murphy, are you ready to proceed with Mr. Gritzmaker?
Yes, Your Honor.
All right, we are on the record in the People's State of Michigan versus Keith Dwayne Gritzmaker. It's file 22-21067-FH. We are here today for a pretrial conference in this matter, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
E.B. Muir, on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Gritzmaker.
And Mr. Murphy, where do we stand with Mr. Gritzmaker's case today?
Yes, Your Honor. At this time, Ms. Muir is offering for Mr. Gritzmaker to plead to operating while impaired, second offense, fleeing and eluding fourth degree, no habitual offender status on that, and with agreement for no upfront jail. At this time, Mr. Gritzmaker does wish to accept that offer. If I got that correct, he does wish to accept that offer again of operating while impaired, second offense, fleeing and eluding fourth degree with no upfront jail. And if I'm looking at the information correct, it would be count 2 is the fleeing and eluding fourth degree. I'm not sure if we need a new separate information or not for the operating while impaired second offense.
That's already, I did an amended already and it's on
Okay.
as count 3.
I think
All right, so I've got an amended information that has count 3's operating while intoxicated second offense. Ms. Muir, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
All right, Mr. Gritzmaker, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
I was not able to hear you. I need you to maybe lift up your device so it's directly in front of your face, please.
Yes.
All right, you are Keith Dwayne Gritzmaker.
Yes.
Mr. Gritzmaker, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, fleeing a police officer fourth degree?
Yes.
You understand the maximum penalty for that offense up to 2 years in prison and or a $500 fine?
Yes.
Do you understand that also that the Secretary of State shall suspend your license for 1 year?
Yes.
Is it also your intention to plead guilty today to count 3, operating while intoxicated second offense?
Repeat that.
Is it also your intention to plead guilty today to count 3, operating while intoxicated second offense?
Yeah.
You understand the maximum penalty for that offense is 5 days to 1 year in jail.
Yes.
Are you satisfied with Mr. Murphy and the advice that he's given you?
Yeah.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Muir?
That's correct.
Mr. Murphy,
That's correct, Your Honor.
is that also your understanding, Mr. Gritzmaker?
Sorry about that. Repeat that again.
Is it your understanding that neither the prosecutor, yourself, or anyone acting on your behalf has discussed a possible sentence with the court?
Right.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Gritzmaker, that if your plea is accepted, you may be giving up the right to appeal issues that were otherwise appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to this plea by application for leave to appeal and not by right.
Yeah.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge of on or about June 9, 2022 in the city of Adrian, County of Lenawee, that you did commit the offense of fleeing a police officer 4th degree?
Yes. Guilty.
And how do you wish to plead to the charge that on or about June 9, 2022 in the city of Adrian, County of Lenawee, that you did commit the offense of operating while intoxicated?
Guilty.
Do you understand that if I accept plea, you'll be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Gritzmaker to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Gritzmaker, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yeah.
Okay, Mr. Murphy, would you like to cover the factual basis?
Yes, Your Honor, thank you. Mr. Gritzmaker, were you indeed in the city of Adrian, County of Lenawee, state of Michigan on June 9th, 2022?
Yep.
And on that date, were you operating a motor vehicle on Riverside Avenue?
I don't believe it was Riverside.
Okay, were you operating a motor vehicle on a public highway in the city of Adrian?
Yep.
Do you recall what streets you were on?
No, the only one I remember has been a.
Okay. When you were operating that motor vehicle, would you agree that you had consumed alcohol prior to operating that motor vehicle?
Yes, sir.
Okay, and would you agree that your blood alcohol content was at least a 0.08 or greater?
I'm sure. Yes.
Okay. Would you also agree that you had prior operating while impaired or operating while intoxicated convictions in November of 2004 and April of 2002?
Yeah.
Okay. And while you're operating that motor vehicle, did a police officer try to pull you over with emergency lights and making audible sirens or anything to that effect?
I'm guessing yes.
Okay. And you knew it was a police officer trying to pull you over? correct?
Yeah,
Okay. And when the officer tried to pull you over, you did not stop, correct?
as far as I know, yes.
Okay, you continued to drive away, accelerating possibly to get away from the officer, correct?
Correct.
Okay. Now, do you recall, did you eventually stop the vehicle, or did you, do you recall the officer coming into contact with you later?
Yeah,
Okay.
I'm satisfied, Your Honor.
Yes, I'm satisfied with factual basis. Thank you.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
Mr. Murphy?
Yes, Your Honor. Thank you.
All right, I will accept the pleas, then they have been given understandably, voluntarily, and accurately. Mr. Gritzmaker has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will report this matter to probation department for a pre-sentence investigation and set sentencing for April 13th at 8:15 a.m.
Your Honor, could we
Mr.
address bond briefly in regards to Mr. Gritzmaker?
One moment, Mr. Murphy. Mr. Gritzmaker, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense, these offenses, and about your background. All right, Mr. Murphy, what is it you'd like to say about bond?
Your Honor, I would ask if Mr. Gritzmaker's his alcohol testing, if it could be the regimen could be reduced down to maybe regular and random. Since this case has happened, he hasn't had any violations of his bond conditions. And as the court could see, there was previous operating while impaired in Mr. Gritzmaker's past. There was a period of time where he was doing fairly well in regards to his alcoholism. Obviously, he fell off the wagon in regards to this event. But again, since he's been on bond conditions, he hadn't had any violations. He has been attending AA meetings, from my understanding, at least 3 times a week. He has, quite frankly, just been doing that and working. So I'd ask the court, again, based upon his performance and the fact that he's taking responsibility for his actions, to consider reducing his alcohol testing down to maybe regular or random.
Ms. Muir, people have any position on that request?
I would leave it to the discretion of the court and probation.
All right, I do have a letter from Mr. Coast in the court's file that indicates Mr. Gritzmaker has been testing since August twice daily and has not had any significant issues. I think given that, I am comfortable with the regular and random testing as opposed to twice daily, so I will modify the bond in that regard.
Thank you, Your Honor.
and what does that consist of there?
That means you'll get notified, Mr. Gritzmaker. Your name will be drawn randomly and you'll get notified of when you'll have to go in and test.
Okay, so the little machine thing is no longer then as of today?
I don't know the logistics on whether they require you to keep a machine in order to test when you're notified or whether they come in. You'll have to talk to Mr. Coast about that.
Okay,
Yeah, Mr. Gritzmaker, talk to Mr. Coast, but your home unit's probably gonna be turned in, and then you'll have to report on the color system. So talk to Mr. Coast about how you do that, okay?
okay, and when was the next court date?
April 13th, I believe, if I'm not mistaken.
Yeah, April 13th at 8:15 a.m.
Okay, thank you.
Thank you, Your Honor.
All right, Mr. Gritzmaker, I'm going to place you in a breakout session with Ms. Holly from the probation department so that she can collect your contact information.
Okay,
All right, Ms. Mull, where do we stand with Ms. Seavey's case?
Thank you, Your Honor. Just for the record, I have only recently been retained on this file, attempting to resolve it. so they can focus on other things. I respectfully ask for a pretrial, as I am new to the case just a week ago today.
Well, I would indicate that it was Ms. Seavey's case to retain a different attorney at this point. We, again, had this set for trial today, which the court canceled. Again, because we were told that there'd be a plea agreement today. So I will allow one pretrial. I'm going to set it for another trial date at the next pretrial, because this case was bound over back in September. So this case needs to proceed to a resolution, and I'll do one pretrial, and then I'm setting it for a trial date at the next pretrial. So we'll set a pretrial for March 15th at 8:15 a.m.
Thank you, Your Honor. Thank you, Ms. Mayor. We'll be in contact.
Ms. Mull, would you please prepare a stipulation in order for that adjournment?
Sure. Is there a specific email I would send that to, Your Honor?
We need to have that sent by regular mail to the clerk's office.
Okay, will do. Thank you. Appreciate your time. I'll be in touch,
Okay,
Ken. Thank you.
Okay.
You guys read those too? Oh, yeah.
Okay, Ms. Curry, we still do not have the facility with Mr. McClarty logged in yet. Just so you're aware, we do have, I see in the file, email confirmation that they were. Sure, that's for today's date.
Where was the writ sent, Your Honor?
All right, so I apologize. I was looking at an older email, so I don't have anything in the file that confirms that there was correspondence with the MDOC facility to get him here today. Do you know where he is located, Ms. Curry?
He's at the Gus Correctional Facility.
Okay. The last email confirmation I have in the file for his appearance was for the December 14th hearing.
Okay. Yeah, I think what happened, Judge, is we picked this date. We had a meeting with you to discuss Cobb's, and then we picked this date. So I don't know if it ever got relayed to your clerk. We had picked. I don't even see Mr. Sneed here today.
Well, I'm here for the prosecutor's office, and the last writ we have in our file was for the December 14th date. And we don't, yeah, so we didn't do one for today. We don't even have a notice for today's pretrial. So we wouldn't have known to do the writ.
Okay.
I don't see a stip,
All right.
an order or a notice.
No, we got the date while we were in the conference.
Okay, so I can set it over for a week, Ms. Muir, if you think that's a sufficient amount of time to get. I think the writs for Zoom conferences are just emails sent to the facility rather than.
I think so
form,
too. I was able to get one done last week in 7 days, but I think they were asked for us to do at least 10 days.
I was gonna say, could we do the 20? I have an in-person at 9 on the 15th, so it makes it difficult to Zoom in, and if I'm not done in time, I have to drive out to the house.
All right, so let's try then for the 22nd. at 8:15.
Okay, the 22nd. Ms. Mears, is this now your case, or should I continue to reach out to Mr. Sneed?
No, it's still Mr. Sneed's case.
Okay, thank you.
Yep.
Okay, so February 22nd on that one.
Okay, thank you, Judge.
Okay, thank you. Sorry about the confusion.
That's okay.
Okay, Ms. Underwood, are you ready to proceed with Mr. Cortez?
Yes, thank you, Your Honor. I've had
All right,
discussions with,
let me call the case. This is People of the State of Michigan versus Juan Manuel Cortez, file 22-21125-FH. Today's date set for pretrial conference. We're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Mears.
E.B. Mir on behalf of the people.
Rhonda Underwood on behalf of Mr. Cortez, Your Honor.
And Ms. Underwood, where do we stand with Mr. Cortez's case?
At this time, Your Honor, we have a plea, I believe, we're discussing with Mr. Sneed to an attempt, Your Honor, and we would like to have a COBS discussion with you prior. So we would just ask for a very short adjournment. Maybe 2 weeks.
All right, we'll do February 22nd at 8:15. Ms. Underwood, would you prepare that stipend work?
I will do so with Ms. Mears' permission.
No objection.
Thank you.
Just if you need a COBS conference, just get with Isaac.
Yep. I talked to him.
I do have this afternoon available if that should happen to work for both of you.
Okay, thank you.
Okay, Mr. Cortez, then you can let the officer that's with you know that you're done with court for today.
Okay, you guys have a good day.
Thank you, you too. Okay, Ms., is it Palapu? Did I say that right?
You did, Your Honor.
Okay, you're here for Mr. Oldenhausen?
I am.
All right. My docket indicates that that is Mr. Amadeo's case.
It
Good
is.
morning, Your Honor. Attorney Scott Grable. I'm sorry to interrupt. I'm filling in for Mr. Amadeo. It's my firm's case for Mr. Oldhouse.
Okay, all right, I was gonna say, I saw Mr. Amadeo in the waiting room for a moment, but then he disappeared again, so.
He's on the road, so I wanted to make sure that somebody was here when you called the matter, and we're ready to proceed, Your Honor. Sorry to interrupt the prosecutor as well as yourself.
No problem. I'll bring in Mr. Oldenhausen now.
Thank you, Your Honor.
All right, we are on the record in the People State of Michigan versus Andrew Oldenhausen. It's file 22-21196-FC. Today's date set for a pretrial conference in this matter. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Palapu from the Attorney General's office.
Good morning, Your Honor. Melissa Palapu on behalf of the people, P74121.
Good morning, Your Honor. Attorney Scott Grable, Grable and Associates Law Firm, appearing on behalf of Mr. Oldenhausen, and I'm appearing in substitution, at least for today, for Mr. Amadeo, who's on the road proceeding to another court matter.
Okay, thank you. And Mr. Grable, where do we stand with the case today?
My understanding, Your Honor, is we're still going through discovery. I think there's also additional discovery that's going to be forthcoming. I'm going to ask the court to I guess, put it down the line for another pre-trial, perhaps in 30 to 60 days. This case is still of an early vintage. It wasn't charged that long ago. In addition, Your Honor, there is one bond condition I'll be addressing later as well.
All right, Ms. Palku, anything that we need to address from your perspective?
No, Your Honor. There's one video that I need to get to Mr. Amadeo. Other than that, all discovery has been turned over as at this point, but there is a lot of discovery for Mr. Amadeo to go through.
Okay, so why don't we set this for 60 days, would be about April 5th. How about April 5th at 8:15 a.m.?
That's fine, Your Honor. That date works for me or Mr. Amadei. One of us would be available without issue.
That works for me too, Your Honor.
All right, and Mr. Oldenhausen, could your office prepare a stipulation in order for that adjournment? I'm sorry, Mr. Grable.
Yeah, we could prepare the stipulation, Your Honor. Not an issue at all.
Okay, and you had indicated you wanted to address a bond condition.
Yeah, just very briefly, Your Honor, it got brought to my attention. So I'm not trying to sandbag the Attorney General's office. Mr. Oldhausen has been contacting monthly as required Judge Morgan's office by phone. And to be honest with you, I think their staff would prefer that not continue. He's on the GPS tether. I'm not sure either in the alternative, he can contact your office monthly. I'm not sure your staff wants that either. Or I would just ask that particular condition be eliminated. As I said, he is on the GPS tether. I'm not sure contacting your office or Judge Morgan's office really facilitates anything of any purpose, especially being on a GPS tether. So I'm going to ask the court respectfully to just extinguish that condition. But as I said, the other conditions, the GPS tether is being maintained. So I don't think that puts the community in any more peril. I'm not sure why Judge Morgan had that condition, but I think his staff is frankly sick of getting calls from Mr. Olhausen, to be frank with you.
And Your Honor, I did speak with Mr. Amadeo about this as well. And that condition was just there because at the onset, we believed that Mr. Oldenhausen would not be able to get a GPS tether and would be returning to Texas. However, he does have a GPS tether and he is staying in Michigan. So as long as that GPS tether remains and he remains in Michigan, I have no objection to eliminating that bond condition.
Thank you. I appreciate that.
You want me to set up the cards?
Okay, so we will modify Mr. Oldenhausen's bond to eliminate the requirement that he contact Judge Morgan's office monthly.
Okay, does that afternoon work for you?
Anything else we need to address?
No, Your Honor, I appreciate the court's time as always. Thank you.
Nothing on behalf of the people.
Okay, thank you very much. Then you are free to log out.
Thank you, Your
Have a
Honor.
good day.
Okay, so let's see. Can you call for Trenton later, please? And I'm sorry, Mr. Daly, who are you here for today?
I'm Mr. Gray, Your Honor. It's on a pre-trial on a PPO.
Okay,
Just need a hearing.
you just want a hearing date?
Yes.
Do you need to do anything on the record?
I'm sorry.
Do you need to do anything on the record?
No.
Okay. Ms. Andrews, how long do you think you'll need?
Half hour, maybe an hour.
Okay. Ms. Andrews, could you find us, we need about an hour for a PPO violation hearing?
I have Thursday, March 2nd. And that would be at 9:30.
Your Honor, I'm already showing a finding for I guess, responsible on this. Is this a subsequent violation?
He had two. He had one violation that was alleged to have occurred on April 7, 2022, and then one on September 1st,
We also have time on Tuesday, the 14th.
So there was a petition filed on September 23rd for an alleged violation on September 1st, 2021. We had a hearing on the original petition that was related to, I think, of April 7, 2022 violation. But he hadn't been served with the other petition. And so we did have a hearing. It just wasn't on this violation.
Okay, I guess I don't have anything on this new violation. The stuff I'm showing is the one we've already had the hearing on. Does the court have anything it can send me? I was just reading through the report we have, and I know for a fact we did that hearing. 'Cause
So there's a petition filed, a petition for order to show cause filed on March 31st, 2022. And then there's a second petition for an order to show cause that was filed on September 23rd, 2022.
Is it possible for you to email me the show cause paperwork? Cause I only have 2 open PPO files and both police reports in it are for the violation we've already had.
Give
So
me a
I just want to
second.
make sure this wasn't a duplicate that maybe got authorized.
No, it's a totally separate case. Phoebe.
Okay, yeah, then I don't have any information on it. Well, I'll track it down. Don't worry about it. Well, I'll be able to figure it out.
I can send it to you in about 30 seconds. Just-
Okay.
I'm almost
Sorry, I
there.
didn't want to delay the docket anymore.
Computer's just running slow. All right, so let's get a date then, and in the meantime, I'll work on emailing this to Ms. Muir. I'm sorry, Ms. Andrews, could you tell us the date you had available again?
I have time on Tuesday, the 14th, if that's too soon.
Well, Mr. Daly's gone the next 2 weeks, so it'll probably
Oh,
have
that's
to be
right.
the first week of March.
First week of March, all right. I have 3:30 on March 7th.
1922, and she's gonna do an amended show cause. She says that the 9/121 violation should have been.
I'm fine with that.
Violation. She said that she was gonna be doing an amended violation.
I got a trial that day in Judge Marvin's court. The second, if you had the second, still.
I have March 10th at 3:30.
That works for me.
All right, Ms. Muir, March 10th at, what was that, 3:30?
Yes.
I'm just checking. I'm unavailable that day.
I have March 17th at 1:30.
I'm available then.
That'll work.
That was March 17th at 3:30.
1:30.
1:30. All right, so for March 17th at 1:30 PM. Ms. Mayor, I did email you the other petition. I would also let you know that Kelly just told me that she had some email correspondence with the prosecutor's office, and apparently there needs to be an amended petition filed because the date in that petition that I sent you was incorrect, and there's a different date for the alleged violation.
Okay.
Anything else we need to address in this one?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
Okay, Ms. Underwood, so I saw your chat message about asking for a new date. You don't need a breakout session with Mr. Greenblaker?
I don't believe that will be necessary, Your Honor.
All right.
Your Honor, I also have Mr. Greenblaker though for some new pending felonies. So I guess depending on, I'm not sure, could I have a breakout session with Mr. Greenblaker and Ms. Underwood to discuss the matter briefly?
He does have the 2 pending district court matters as well, and those have a pretrial on February 14th.
And there's a new child support felony coming down the pipes too.
Then I believe the only thing I have Mr. Greenbaker on is the violation. So,
Right.
yeah, I would be more than happy to do a breakout.
Okay. All right.
Judge, I don't know if you can see or not if our new warrant has been entered, because that might be something that he can get arraigned on down in district and start that process moving while he's in custody. I don't know if my officer has gotten down there to swear it to yet.
If I have the ability to do that, I don't know how to do it. So.
I don't either. So I don't, but okay, thank you.
Okay, sir, that just joined the meeting. Are you Mr. Wright?
Yes, sir.
All right. Okay, Mr. Wright, your attorney is in a breakout session with another client right now, so I'm going to put you back in the waiting room until he is ready to handle your case.
Thank you, Your Honor.
Thanks. All right, Mr. Holt, your attorney, Mr. Murphy, is in a breakout session with another client right now. So I'm just going to leave you in the waiting room until he's ready to handle your case. Okay, Mr. Dagger Margosian, you're here for Zane Ridenour.
Yes, Your Honor.
Okay, do you have anybody else this morning?
Just one in Judge Anselm, but that's the only one with you.
Okay, and Mr. Ridenour also has David Goldstein on a couple cases. Do you happen to know if he's over in Judge Anselm's court right now?
Your Honor, Mr. Goldstein and I and Ms. Meir exchanged emails yesterday. Mr. Goldstein is in trial in Washtenaw, so I don't think that he's going to be able to. I don't know what his situation is. I don't know if he's getting coverage, but in any event, the three of us basically talked about the case, and I think we're all in agreement that we're looking for an adjournment on all these cases, probably a short adjournment, but I think we're reaching the resolution here.
Yeah, Mr. Goldstein did reach out and ask if we could adjourn this pretrial, so I don't anticipate he'll be appearing or having anyone appear for him.
Okay, let me take care of Mr. Green Blaker first, and then we'll do that. Okay, so we're on the record now in the People of State of Michigan versus Trenton Jonathan Green Blaker. It's file 22-21192-FH and 20-211. I'm sorry, 20-20114-FH. 22 cases set for a pretrial hearing. The 20 cases set for a probation violation. First, can I have the attorneys place their appearances on the record?
Good morning, Your Honor. Oh, sorry. Sarah Brenner, Assistant Attorney General for the child support case, Your Honor.
Phoebe Merrimack, the people for the case ending in 21192.
Matthew Murphy, appearing on behalf of Trenton Green Blaker for file number 22-21192 today. And I believe moving forward, I'll probably represent him on the violation of probation, but Ms. Runda was on that today.
Rhonda, I'll do it for Mr. Green Blaker on the violations today, Your Honor.
All right, and so there was some discussion, I think, off the record about some additional charges that Mr. Green Blaker may have coming, or a district court, a case that's in district court at the moment. So where do we stand, and what do we need to do? I guess I'll defer to Mr. Murphy at this point, since you indicate you may be taking over everything.
Yes, Your Honor. Thank you. And speaking of Ms. Underwood, what we were going to ask if we could do today, I'm not sure about the status. I know Ms. Brenner warned us or informed us that there may be a new pending felony based upon failure to pay child support. But at this time, Mr. Green Blaker has been in custody for quite some time now, since December. Now, the new pending felonies, I haven't had a chance. I don't have an offer from those. So Mr. Green Blaker was going to ask to continue a not guilty plea on those. He wasn't going to plead as charged on those. I was going to ask to continue those for another pretrial. Obviously, with the multiple attorneys and the multiple prosecuting attorneys in this matter, it's just a matter of logistics, I guess, trying to figure out if we can get something that's going to cover everything. So with the violation of probation, we'd ask for a continuation of a not guilty plea on that and a setting of another pretrial for another date, along with the underlying or with the new pending felony. And then if Ms. Brenner, if they do issue a new child support case, obviously we'll see if that can get processed and up in front of Judge Oldsaver before then. But if there's no objection, I'd ask for that. And then if we could possibly address Mr. Green Blaker's bond.
All right, any issues that anyone else needs to address in these cases at this point?
No, Your Honor.
Oh, Your Honor.
All right, so the next available pretrial date I have is March 8th at 8:15.
That works for the defense, Your Honor. Thank you.
For me as well.
All right, so we'll set another pretrial for that date. Mr. Murphy, would you do stipulation and order for those adjournments?
Yes, Your Honor.
And what did you want to say about bond?
Your Honor, at this time, I'd ask the court to consider giving Mr. Green-Blaker a personal recognizance bond. I understand, obviously, the concerns, the violation of probation stems from an allegation of not reporting. Now, Mr. Green-Blaker, he understands he has been in custody now for a period of time. He understands the importance of being in communication with both his attorneys and with the court. I do believe that moving forward, he will appear moving forward and address these cases. I think that the concern of him not appearing could be alleviated through requiring him to appear in person every week or every day, or the placement of a GPS tether. I just don't know financially because he's not able to afford his bond if he'd be able to afford a GPS tether. But obviously, he would understand that there's conditions. I think that down in district court, those cases do involve it is an allegation of domestic violence. Those cases are up for a pretrial next week. There are bond conditions on those cases as well that Mr. Greenberg will understand that he has to abide by. That would involve no contact with the complaining witnesses in those matters. So I do believe that Mr. Green-Blaker would abide by those conditions moving forward. So I think that he wouldn't be a flight risk, and I believe that he would be, that again, those conditions would alleviate any concern the court would have for Mr. Green-Blaker's or the safety of the community or his safety to himself. So that's the court to consider at this time, reducing his bond down by personal recognizance bond for both the pending felony and the violation of probation.
Your Honor, on the violation, I would strongly object to the PR bond. He absconded from probation on the child support case. He's made zero effort to make child support payments. He's shown no reason for us to believe that he's going to start complying and start checking in since he's been on the lam for so long. And he's got so many things going on. I'd ask that you hold him in custody.
I would as well, Judge, considering he has 4 new criminal cases at this time.
All right, so the felony file is he's charged with assaulting, resisting, obstructing police officer. He's charged as a fourth offense notice. Offenses listed in that 4th offense notice include conviction for assaulting, resisting, obstructing a police officer in 2008. Attempted fleeing police officer in 2014. In the child support, which is the other case that I have in front of me today. In that child support case, Mr. Green-Blaker is charged with a 2nd probation violation. The 1st probation violation he was found guilty of failing to report. The 2nd violation is, again, a failure to report. Mr. Green-Blaker is alleged to have stopped reporting in September of 2021 and was not picked up on the bench warrant until December of 2022. I think under those circumstances, I don't believe the PR bond would satisfy my concern or appropriately address my concern that Mr. Green Blaker would appear. He has shown through his actions that he does not appear and does not comply with the requirements of the court. And so I think something more than that is required, particularly since there are apparently new charges that he's going to have to face. I'm going to leave bond where it is for now. I may be willing to consider, once we know when the new charges are filed at the next pretrial, what they are and what bond considerations are going to be with that. I might be willing to consider a tether at that point, but I don't think at this point that I'm going to do that. So I'm going to leave the bond in place for now.
Yes, Your Honor. Thank you.
Thank you, Your Honor.
All right, Mr. Green Blaker, you can let the officer that's with you know that you are done with court for today. And do we need to do anything on the record for Mr. Ridenour, Mr. Dagger-Margosian, or do you just want a new date?
Your Honor, I would like to talk with him if he's available. Ultimately, we will just be getting a new date, but.
Okay, we'll call for him right now.
Thank you, Your Honor.
Mr. Murphy, Jonathan Wright is here. Do you need a breakout session with him?
Yeah, I guess just briefly, probably.
Thank you.
Can you see me and hear me all right?
Yes, just one moment, Mr. Wright. I'm going to place you in a breakout session with Mr. Murphy so that you can speak with him privately.
Thank you, Your Honor.
Okay, Mr. Ridenour, I'm going to place you in a breakout session with Mr. Dagger-Margosian.
Yes, sir.
Okay, we are on the record in the people of the state of Michigan versus Jonathan Thomas Wright, file 22-20807-FH. We are here today for a final pretrial conference in this matter, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir for the people.
E.B. Muir on behalf of the people.
Matthew Murphy appearing on behalf of Jonathan Wright.
All right, Mr. Murphy, where do we stand with Mr. Wright's case today?
Yes, Your Honor. At this time, I was speaking with Mr. Bayonetto about this case. The prosecution's offer at this time stands for Mr. Wright to plead, which would be to count 1, carrying a concealed weapon with no upfront jail. At this time, Mr. Wright does not wish to accept that offer. I think we are scheduled for trial on this on the 21st of February. So I would ask that we just continue to have that trial date.
All right, have jury instructions and what are your questions been submitted?
Your Honor, I have not submitted my jury instructions. They were just going to be the regular model jury instructions. There wasn't anything that I planned on asking outside of those. I do believe I have received the proposed ones from the prosecution. I have no objection to those, but I will submit my proposed ones by the end of the day, Your Honor. I apologize.
If Mr. Murphy stipulates to Mr. Banetto's, then I don't, we're fine with those.
Okay, so we're set for trial on February 21st at 9 a.m. Mr. Wright, you will need to be here in person for the trial.
Yes, Your Honor.
And just for the court's point of contact, if you need anyone on that, that is Mr. Banetto's case.
Thank you, ma'am.
All right. Thank you then, Mr. Wright. You can go ahead and log out.
Thank you, sir.
Thank you, Mr. Wright. Again, my secretary will contact you, okay?
Yes.
Thanks.
Mr. Murphy, do you need a breakout session with Mr. Holtz?
I don't believe so, Your Honor, no.
Okay, we're on the record then in the People's State of Michigan versus Timothy Allen Holtz, file number 22-20685-FH. Today is the date set for a pretrial conference in this matter. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
B.B. Muir on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Holtz.
All right, Mr. Murphy, where do we stand with Mr. Holtz's case today?
Your Honor, I was speaking with my client at length about the case, trying to get an understanding of what happened and what has progressed on this case since I was appointed to it. I was going to ask if we could do another pretrial if Ms. Muir wouldn't object to that, because I just need some more time to speak with him and with Ms. Muir further, if it is her case, as she is on it, about where the prosecution's stance is on this case. I believe that I would need more time than I would be able to do just in a breakout session this morning. So that's why I'd ask if we could do another pretrial.
And Your Honor, yes, this case just had kept getting delayed because it was difficult to work with Mr. Holtz on the record with him representing himself or maybe hiring an attorney. So I have no objection now that he has an attorney that Mr. Murphy and I can discuss the case. But if it streamlines things, I would like to place the offer on the record at this time. And it's been an offer that's been outstanding for about a year now. But the offer is to plead to count one as charged. I've estimated the guidelines on that to be about 0 to 9 months. And I would not add a felony firearm charge if that plea is, and obviously the remaining charges would be dismissed as part of that plea agreement.
Okay, thank you.
All right, so this is a case that was bound over on January 10th of 2022. So it's over a year since it's been bound over. Public Defender's Office was appointed on November 4th, 2022. So I just can't continue to let this case languish. So I'm going to set a trial date. It'll be a ways out, but we need to do something to get this case off of
Understood, Your Honor. Thank you.
0. So how many days, Ms. Muir, do you think is appropriate for the trial of this matter?
Just one, Your Honor.
All right, Mr. Murphy, do you agree with that?
I guess at this point, I think 1 or 2, probably 1 will be sufficient. Again, talking with Mr. Holtz, there's some issues I need to talk with Ms. Muir about. So I think I'll defer to her understanding the case more. I'd say 1 day would probably be sufficient at this point.
All right, Ms. Andrews, can you find us a 1-day jury trial date, please?
I have May 5th. And that would be back up to Winans.
That would work for the defense, Your Honor.
That's fine, Your Honor.
So we'll set the trial date for May 5th. And the final pretrial for April 26th.
Yes, Your Honor.
Okay, the court will issue a scheduling order and send that out to you.
Thank you, Your Honor.
Thank you.
Okay, thank you. All right, we are on the record then in the people of the state of Michigan versus Zane James Ridenour, files 22-20724-FH, 22-20863-FH, 22-21169-FH, and 22-21181-FH. Those are all set for pretrial conferences this morning. We're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record.
BB Mir on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Ridenour on cases ending in 169 and 181.
All right, and with respect to files ending in 724 and 863, David Goldstein is the attorney for Mr. Ridenour in those cases. It's my understanding that he is unable to be here because he is in a trial, and that the only thing we need to do today is adjourn the pre-trial. Is that correct, Mr. Dagger Margosian?
It is, Your Honor.
All right. So the next date I have available is March 8th at 8:15.
That's fine.
Okay, so March 8th at 8:15. Mr. Dagger Margosian, could I ask you to do the stipulation and orders for your two cases? And Ms. Mir, would you do the stip and orders for the other two cases?
I can just do them all, if that would probably be easier.
Okay,
I agree.
certainly appreciate that then.
Yep.
All right, Mr. Ridenour, you can let the officer that's with you know that you are done with court for today.
Thank you, sir.
Mr. Murphy, we have a few of your clients who are not here. Julia Betts is not here. Is Brandon Madison?
Brandon Madison is in jail.
Okay, can you call?
Is she in jail?
We'll call for Brandon Madison right now. No, Ms. Betts is not in jail. She was picked up on a bench warrant that I dismissed because she didn't have notice of the date that she missed.
Yes, and just to inform the court, she does have a misdemeanor downstairs, and she has a new felony she was charged with, but she was given PR bonds on those ones as well. So I thought she was. I think, well, I guess we'll try to reach her and then we'll address it on the record if we don't get her here. Thank you.
Bo Parker is not here.
He's in jail.
Oh, he's in jail. Okay, he's apparently in jail, so we'll.
Mr. Parker's in jail?
Yes, that is what Kelly's telling me. So we're calling for Mr. Madison right now, and we'll call for either him or Mr. Rutledge next.
Oh. Well, we can do that if you want to take the kids to school. Oh. Should we could do that. I mean, we didn't get out there like 8 o'clock at night. Days like there, swim that night, until all around, whatever. We get one, though, I'll look. Huh? You got a haircut, huh? Which one?
You getting out? Yeah.
Okay, you're Mr. Madison, sir?
Yes, sir.
Mr. Murphy, do you need a breakout session with Mr. Madison?
Just briefly, Your Honor.
Okay, we are on record in the People of the State of Michigan versus Brandon Lorenz Joe Madison, file number 23-21242-FH. Today's date set for a pretrial conference in this matter. And, oh, I'm sorry, this is an arraignment. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record.
BB, Mayor, on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Madison.
All right, Mr. Murphy, does Mr. Madison wish to have the information read?
No, Your Honor. At this time, we acknowledge receipt of said information, the witness list, and the discovery request from the prosecution. We were to ask for a continuation or an entrance and continuation of a not guilty plea. I have been speaking with the prosecution. I was seeing if we could get something worked out today in regards to a plea offer, but we're not there at that point. I think if the court would schedule a pretrial, we only need probably a week or two. Mr. Madison has pending sentencing on March 8th or 9th. I believe it's March 9th. So I was hoping to get a pretrial or something worked out in this case prior to that sentencing date. If the court doesn't have it in its schedule, obviously I'll see if I can get something figured out and do something off the schedule if possible. But at this time, that's what we're asking for is an entrance and continuation of a not guilty and a pretrial scheduled. Thank you.
All right, I could set it for next week, the 15th. Is that gonna work?
That'll be fine, Your Honor. I think I should have an answer about the plea offer by then.
So we'll set it for February 14th. I'm sorry, February 15th at 8:15 a.m.
Thank you, Your Honor.
Mr. Madison, you can let the officer that's with you know that you are done in court for today.
Yes, sir. Thank you.
You.
Hello, it's Kelly again at Judicial Papers. Could we get Lucas Rutledge in a room for the judge, please? Thank you. Bye.
Judge, I have a couple of arraignments. I was wondering if we got waivers on. One is Joseph Taylor, one is Jamie Todd, and the other is Lucas Rutledge.
Yeah, we have waivers for Taylor and Todd. Both of those are set for March 8th. Rutledge, we did not have a waiver on, but we just called for him at the jail.
Okay, thank you.
Ms. Underwood, do you need a breakout session with Mr. Rutledge? You are muted, Ms. Underwood.
I don't believe I do, Your Honor. But I do not have, and we're trying to get it. I do not have a copy of the information on these files, Your Honor.
Did you ever, get a sample? No, not yet. Okay, yeah, I was going with that other one.
Rhonda, do you want me to email them to you?
Yeah, if you have them available to you quickly, that I'd appreciate that, Ms. Muir. I was trying to do that, but it takes me a little while to.
Yeah, I'm gonna email them to the PDO email though, because I know that's how we typically send them, and I don't want to send them to Rhonda's personal email.
We got to order this one. Got candy corn, you want corn, you want more. I think
I'm not mad. Yes, I want to be your best friend.
Okay, I've just sent those.
We will go that way, I promise you. We will respect and where we're at, who we are, and any man as a man, but they got this, they lost, all right. They didn't do this, well, white, we're not fucking do this, you already lost the battle. Yeah, we move around like we do something like that. But it's stupid, I know that. We need to throw measure out. But when you're stuck in this environment your whole lifetime, it brings you back to it. I gotta basically go back and fuck down.
Okay, do you have those yet, Ms. Underwood?
Thank you, Your Honor. I don't see them yet.
I ain't the nigga I'm sitting on saying this shit. What am I telling that? Tell you what I told her. Go now.
Thank you, Your Honor. I got them.
Right. So we are on the record then in the People's State of Michigan versus Lucas Allen Rutledge, file 23-21240-FH and 23-21241-FH. Here today for an arraignment. Please have the attorneys place their appearances on the record.
BB, Mayor, of the people.
Rhonda Underwood on behalf of Mr. Rutledge, Your Honor.
All right, and Ms. Underwood, does Mr. Rutledge wish to have those informations written?
Yes, I have. We would waive the reading of the complaint, Your Honor. I would acknowledge its receipt and the receipt of the witness list and prosecution request for discovery. At this time, I would ask the court to enter a not guilty plea on Mr. Rutledge's behalf and set this matter for kind of a quick pretrial, Your Honor. We are trying to get a situation where Mr. Rutledge can have his bond changed, Your Honor. We're trying to get an address for Mr. Rutledge. and, or in the alternative, rehabilitation. But that has not come about yet. So we would like kind of a quick pretrial.
And Your Honor, my understanding is, Mr. Rutledge's bond currently as is set is that he can be released on PR to an inpatient facility. And his caseworker at Community Mental Health was working on getting him a spot in inpatient. So I guess I just want to make sure his bond does reflect that, because I think he does have a spot to go. And we'd like to see him go there before we resolve these cases.
Thank you, Ms. Meir. Yeah, Your Honor, a quick pretrial, I think.
All right, well, I'm running into a problem because just about everyone this morning has asked for a quick pretrial. So
I totally understand.
I'm
Your
out
Honor.
of quick pretrials.
And I guess that's why I bring that up, because I don't think we do need a
So,
quick pretrial. I
yeah.
think we need a far out pretrial, because the hope is that he goes inpatient somewhere and he finishes his treatment before we resolve these. So that's why I think opposite. I think we don't need a quick pretrial.
So I guess what I'll say then with respect to bond, I'm flipping through right now to see if I can find the conditions and whether it permits him to be released on a PR to a inpatient treatment facility.
But okay, the plug about here, get the plug right here, and I gotta get out and run.
So it looks like at one time he had some provisions for a PR bond, but then they brought him back into court and took those away. So I mean, I guess it sounds like the plan is for him to get to a treatment facility. So if his bond conditions don't include that he can be released to a residential treatment facility, I'll modify the bond to do that now. As I understand it from Ms. Meir, that's what they want to see happen. So we'll just make sure that that's the case. And I'll set a pretrial for, at this point, March 15th at 8:15 a.m.
Did you say March 15th, Your Honor?
Correct.
Thank you.
And we'll just check in and see what the status is with respect to any inpatient treatment facility at that time.
Thank you.
Thank you.
Okay, Mr. Rutledge, you can let the officer that's with you know that you're done in court for today.
Okay.
So you're all set. Thank you. Parker, Bo Parker.
Good.
Yeah.
Hello, it's Kelly again. Could we have Bo Parker for Judge O'Safer, please? Thank you. Bye.
Ms. Muir, on Katie Corin versus Jesse Mills, it didn't look from my file like that got served yet. Is that correct?
Yeah, I don't have that served. I don't even have our show cause signed by Your Honor. So I think we just need a new date.
Do you have a new one? 'Cause I signed one back on November 28th.
Oh,
That's in the file.
okay. The copy we have is blank, so maybe that's why it didn't get served. Can you email me
Okay.
the one that you have signed or have someone
Yeah.
email? Okay, thank you.
I guess so, they call for you.
And then,
Oh, it's
we set that for March 15th.
Okay.
All right, Mr. Murphy, do you need a breakout session with Mr. Parker?
Please, Your Honor.
Yeah, good. I'm gonna want to talk to him for a minute.
So on Corin versus Mills, I just sent you 2 orders, but they're both for the same date. The February one I don't have in the file, the November one I did, but so we got 2 petitions for the same date.
Okay, let me take a look.
Okay, we're on the record in the People of the State of Michigan versus Bo Daniel Parker, file 22-21193-FH. Today's date set for a pretrial hearing in this matter. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on record, beginning with Ms. Muir.
Phoebe Muir, on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Parker.
All right, Mr. Murphy, where do we stand with Mr. Parker's case today?
Yes, John, at this time, I was going to ask if we could schedule a jury trial on this matter. I mean, the situation seems fairly complicated, but I think if we're focusing on what's charged with Mr. Parker, that actual trial should probably take maybe 1 day. I think if you look at what he's charged with, so I'd ask if we could schedule a 1-day jury trial.
All right, Ms. Muir, anything to address from the people's side?
No, Your Honor.
All right, Ms. Andrews, could you find us a 1-day jury trial date, please?
And it can be a little bit farther out. I think there's gonna be new charges coming. And I anticipate defense asking for a global resolution on that. So we'll try and get those charges filed as soon as possible. So we can
I
get that
have,
moving.
we can set a second backup on May 5th.
So that would actually be so 3 on May 5th. It's a
Right.
big lunch.
Your Honor, could we just do, based upon what Ms. Muir said, she had mentioned before, or I had heard before, I forgot if it's from Ms. Muir or not, that there was possible pending charges, but that was a bit of time ago. I didn't know if anything was coming from that. So could we possibly just do another pretrial if the prosecution wouldn't object? Just to see the status of any new pending cases, and then at that point, see if we need to schedule a trial or not. Sorry, I think I don't mean to backpedal. I think that may be more appropriate based on what Ms. Muir indicated.
Okay, Ms. Muir, any issue with that?
No, that's fine.
We do pretrial on March 15th at 8:15.
That's fine for the defense, Your Honor. Thank you.
Do you have any objection to doing that on the 22nd instead, going 1 more week? Judge?
That'd be fine for the defense as well.
So March 22nd.
If that's okay.
March 22nd at 8:15. Mr. Murphy, would you prepare that stip in order, please?
I will, Your Honor. Thank you.
Okay. Mr. Parker, you can let the officer that's with you know that you're done with court for today.
Yes, sir. Thank you.
Thank you, Mr. Parker. Again, when you're done serving a sentence, contact my office, okay? When you get released.
I will do, sir.
Thank you.
Thank you.
Matt, what is his out date?
He's got 10 days on a contempt of court. He's posted bond on this one. So there's a misdemeanor contempt of court downstairs. I think he got 10 days on Friday, he said. He's not being held on this or any, I think he's posted on the other cases. So that's the only thing that's holding him is that 10-day sentence, I believe.
I called him myself and turned myself in.
Okay, thank you. I just wanted to know.
Yeah, so he should be out by the end of this week, I think, or beginning of next week. So, thank you. And Your Honor, we had left a message with Julia Betts. I didn't know if Your Honor wanted to proceed on the record with that case, but we haven't heard back from her this morning.
So, right? Thing good? Good. Yeah.
Okay, we are on the record in the People's State of Michigan versus Julia Betts. It is file number 22-21100-FH. Today's date set for an arraignment in this matter. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
BB Mir on behalf of the people.
Matthew Murphy appearing on behalf of Ms. Betts.
All right, record should reflect this matter was set for hearing this morning at 8:15 a.m. It is now 10:24 a.m. Ms. Betts is not present here in the courtroom, and she is not logged into the Zoom session. There is no one in the Zoom waiting room at this point. I have been monitoring the Zoom session and Zoom waiting room since approximately 8 o'clock this morning, and I have not seen Ms. Betts present at any time. I have identified anyone who's not logged in under their own name. Mr. Murphy, do you know anything about Ms. Betts' location this morning?
Your Honor, I honestly don't know where she is this morning. In regards to Ms. Betts, she had a bond hearing on Monday down in district court covering a new pending felony of an allegation of prisoner in possession of contraband and possession of a controlled substance from a few months ago. And there's a pending, I forgot, a pending misdemeanor down there. She was given a PR bond on Monday in those cases. Now, if Your Honor recalls, Your Honor had given her a PR bond on this case on Friday, I believe, based upon the fact that there wasn't, you believe that she wasn't notified of the arraignment date. Now, I'm saying this because on Monday, she was asking over Zoom when her next court date was, and I had informed her that her next court date was the probable cause conference on February 10th, this Friday. I believe that may have, obviously I told her the next date's the 10th. I didn't tell her it was the 8th. I forgot about this arraignment date. I do believe that that's probably why she isn't here, is because of that, Your Honor. I would ask if we could possibly do a show cause for Friday, or maybe a bench warrant, hold it for 48 hours. I believe that at the very worst, she will be in district court on Friday, and we'll be able to have her appear, or I could have her, I did intend to waive this, I just hadn't had her sign that. If I can get a waiver signed on Friday, that would be good as well. So I'd have to court to do, again, either do a show cause for Friday or just hold the bench warrants in abeyance for 48 hours.
All right, I think I just need to correct one thing. Mr. Murphy, you had indicated that she didn't have notice of her arraignment. I don't think that was the case. She was bound over. The arraignment was set out. She didn't appear at the original arraignment on October 19th. At that point, I issued an order to show cause directing her to appear on November 2nd. it was that order to show cause that didn't get prepared and served on her.
Yes, Your Honor, I apologize. Thank you for correcting the record.
Yeah, no problem. I just wanted to have a clear record of what happened. So I did dismiss that show cause when she was picked up on a warrant that I issued on the 2nd for failure to appear that day. So she was in court on February 2nd on that issue, and I advised her on the record on that date of what the next, what her next court date with respect to this case was going to be. And we did send out a notice for today's date. I guess at this point, Mr. Murphy, I will give her the opportunity to see if she shows up for your hearing on Friday. I'm going to give her the 48-hour grace period, even though I don't think I'm required to at this point.
Thank you, Your Honor.
But if she has not contacted court by Friday, I am going to revoke and forfeit her bond, issue a bench warrant for her arrest for failure to appear here today.
Yes, Your Honor. Thank you.
Would set bond on that bench warrant if it issues in the amount of $50,000 cap. Okay, Mr. Murphy, did you have anything else?
That's all that I had on my docket, Your Honor. Everyone have a good morning. Thank you.
Thank you. So the only person I have left at this point is Marquise Hernandez. And we're waiting on Mr. Malero to get logged in here for that one.
And Ms. Wise is here for that, so I'm gonna go ahead and log out. So thank you.
Thank you, Ms. Muir.
So no Bishop, Duvall, or McClarty?
Vol got adjourned. Do you have that date? The fall is adjourned to March 8th.
Okay.
Clardy was also adjourned to, do you have that date? Clardy is February 22nd. And I'm sorry, I didn't catch the name of the
Bishop, Nicholas Bishop. It was Salas.
Nicholas was a waiver. His pretrial is March 9th.
Okay, thank you. So we're still doing Hernandez?
Yes, whenever Mr. Malero gets logged in here.
Okay.
Do we have Silva at 10:30 as well? Crabtree, okay.
Ready for Mr. Silva though.
What?
File that shows his presence.
Over here. I'll be right over here. All right.
What are we getting?
Just a notice.
Okay,
Sorry about that, Your
Mr. Ambrose and Ms. Brueggemann, we're not on the record yet. I just looked at the file and I don't have anything in my file that shows that we requested Mr. Silva's presence at today's hearing. Mr. Ambrose, I guess I would leave it to you if you want to proceed despite that, or do you want us to set this for a different date and we'll make sure that we get a writ for his presence?
Okay. I can waive his appearance for this type of motion.
Okay, yeah, if you want to, that's fine. I mean, like I said, either way is fine with me.
Yeah, I would waive his appearance.
Okay. All right, we are on the record then in the people of the state of Michigan versus Cruz Angelo Silva, file number 22-20773-FC. Today is the date set for a hearing on the defendant's motion to correct a pre-sentence investigation report and amend jail credit. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Brueggemann for people.
Jennifer Brueggemann on behalf of the people.
It's Ronald Ambrose appearing on behalf of Mr. Cruz Silva.
Okay, so I have received both the motion and the response. I've read both of those. So Mr. Ambrose, if you have any oral argument at this time, you can. Well, I guess let me first let us address on the record the fact that Mr. Silva is not present in the Zoom session today. I had indicated to Mr. Ambrose off the record that I don't have anything in my file that indicates we requested his presence for this hearing today, and gave Mr. Ambrose the option to proceed without his presence or adjourn to another date. So Mr. Ambrose, it's my understanding at this time that you are in agreement with proceeding without Mr. Silva being present today. Is that accurate?
That is correct, Your Honor. For a motion like this, I can waive his appearance. It's a post-conviction motion. Yes, I will waive his appearance for this.
Okay, and I apologize. He has two files that were here on 21-20550-FC as well as 22-20773-FC, and the motion applies to both of those. So, all right, Mr. Ambrose, you can proceed then with your argument.
Yeah. First off is with regard to the pre-sentence investigation report. There was my copy of the pre-sentence investigation report does not reflect the changes that were made or that were requested at the time of the sentencing hearing. There was a remark that was made by the defense that the defendant disagreed with certain information within the pre-sentence investigation report, and the judge, Your Honor, stated that you would note that for the within the agent's description of the offense. My copy of the report did not reflect that. The second thing as part of this pre-sentence investigation report is number 4 of 7 states, and I just would ask the court for a more specific correction to that. Number 4 of 7 states 6 to 15 years MDOC, 2 flat for felony firearm. I would ask that the court change that to 6 months to 15 years. The way that it's reading right now, it indicates or could be read to suggest 6 years to 15 years, when in fact it was 6 months to 15 years. The third area is with regard to jail credit. I have now received information from the Lenawee County Prosecutor's Office that appears no longer to be an issue. They confirmed that a parole detainer was issued against my client, so I don't have any argument in that regard. And that's it.
Okay, thank you. Ms. Brueggemann.
Thank you, Your Honor. The main issue obviously for our office was the jail credit, and since yes, it appears that there was a parole detainer, he's not entitled to credit. The other two issues, I cannot read the lien on our system as far as the 6 month. So maybe probation can speak to that, Mr. Stevenson. And then the other issue with regard to disagreeing with the facts of the events that happened. If I know he objected to that, if I would just defer to whatever was agreed to at the time of the sentencing from Your Honor, as far as correcting those things. I don't have any objection beyond what was already said at the sentencing. So my main concern was the jail credit. So I'll just leave it in the court's discretion.
Okay. Mr. Stevenson, do you have any further information about that 6 month versus 6 year issue?
No, we can make that correction to 6 months.
Okay, so 6 months on, let's see, that was number 4 of 7 in the criminal history report. And then I do recall having a discussion and indicating that we would include something that says that the defendant did not agree with the statement of facts. Can you add a statement in that regard to Mr. Silva's report?
Yes, would you want that to indicate that he disagrees with the agent's description of the offense? Would that be accurate?
Yeah, I think that's essentially what was said on the record, just that Mr. Silva disagrees with the agent's description of the offense. Is that satisfactory, Mr. Ambrose?
Yes, I think that's what was reported at the time of the sentencing, so I would agree with.
All right, so I will grant the motion to that extent, deny the motion with respect to the jail credit issue, as that is no longer an issue.
You have my number.
All right, and I will prepare an order to that effect that we will send to you.
Very good. I appreciate it. Thank you.
All right, thank you. Then you can go ahead and log out.
Thank you, Your Honor.
Will that order be sent out to me?
Yes, we will serve that on you.
All right, great. I appreciate it. Thank you.
Thank you.
Quit for a year and listen to the Navy, come back out, do the good stuff. Yeah. Yeah, you're on the left, wait for him to call you. He never called me. Oh, wait, I didn't. Saying, right, I'm saying, I know. I would hang out with outside. It's like 15 people. So literally any platoon I end up on, I'd still have fun. Literally the only thing like. You say when you do something, you hear it, that. No. Yeah.
Judicial savers, could we have Marquis Hernandez in a room for the judge, please? Thank you. Bye.
Good morning, Mr. Malero. We just called for Mr. Hernandez.
Okay, Judge, thank you.
All right, Mr. Malero, are you going to need a breakout session with Mr. Hernandez?
Yeah, real quick, Judge, if that's okay.
Okay.
Can you sign that? Sign David up there.
Okay, we're on record now. The People's State of Michigan versus Marquise Hernandez, file 22-20877-FH and 22-20878-FH. These are both set for pretrial conferences this morning. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Salvatore Malero on behalf of Marquise Hernandez.
Okay, and Mr. Malero, where do we stand with Mr. Hernandez's cases today?
Judge, this is a kind of has had a kind of a history winding its way up and down the court system. But I would like to adjourn this for another pretrial. I'd like to talk to Ms. Wise and then talk to Mr. Hernandez about any type of resolution short of trial. So that would be our request today. I also would like to address a bond in this matter after we're finished with this issue.
All right, Ms. Wise, is there anything to address from the people's standpoint?
As far as adjourning it for another pretrial, no, Your Honor.
All right, so Mr. Malero, you're correct. This is had a, was bound over. It got remanded for an exam, I think, and then bound over again second time back in November. I would say at this point that the case needs to start moving toward a resolution. It's just getting to that age. So I will, I'll adjourn for one last pretrial. But if there's no resolution at that point, I think it's time to set it for trial and to get this resolved.
I agree, Judge, and I thank you.
So I'll set it for a pretrial then on March 15th at 8:15 a.m.
Yeah, that's fine, Judge.
Okay. Mr. Malero, would you prepare stipulation and orders for the adjournment?
Yes.
All right, what is it you would like to address about bond?
Your Honor, Mr. Hernandez, in this matter, he's a lifelong resident of the county. He is employed or was employed at the time he was arrested on this matter. I'm not aware of any failures to appear. I know that he is vigorously asserting his innocence in this matter and wants to, I think if he's released on a appropriate bond, it's far better for me and him in aiding and preparing and establishing a defense for him. I know that he intends to fight this case all the way, whether we resolve it or there's a trial. So he has a great incentive to appear. He was aware of the possibility of these charges prior to them being filed. He didn't leave, he didn't flee. They are very serious charges, but I would ask the court to consider reducing the bond to perhaps, I would say perhaps a $50,000 cash or surety bond with a prospect of a tether and perhaps curfew and conditions of no contact and perhaps restrictions on any other like computer or communication other than through with his attorney so that he could help me better prepare for his defense. That would be our request, Judge.
Your Honor, what's the bond currently set at?
It is $170,000 cash or surety in the file ending 877, and it is $80,000 in the other case.
8,000?
80.
80.
Oh. Your Honor, we did have a preliminary examination in this matter, and the defendant is charged with multiple counts, including CSC and kidnapping. I would indicate to the court that based on the nature of the charges, he does pose a threat to the community. And I would say that the bond as stated by the court is reasonable. So I would oppose any PR bond or bond reduction.
Judge, if I may.
Go ahead.
I would dispute the threat to the community. I mean, I think if the prosecutor wants to argue he's a threat to the alleged victim in this matter, I don't think I would dispute that assertion. And I think the court can fashion appropriate conditions to allay any concerns to that. But as to the community, I would disagree with it.
Okay, so I'm going to take it under advisement. I'll issue a written opinion. I'll have that out probably by the end of the day.
All right, thank you, Judge.
Thank you.
Thank you, Mr. Hernandez and Ms. Wise.
Thank you. Your Honor, do you have Lucas Crabtree still?
Yes.
Sam, do you know where John is?
I
just
heard he
logged
was in his office hiding under his desk.
Okay.
Yep, there he is. He heard you. I think that's all I have with you, Judge.
Yep, that is. Thank you, Mr. Valero.
Thank you. John? Jackie's looking for you.
Oh, I see her.
All right. All right, we're on the record. This is People of the State of Michigan versus Lucas Edward Crabtree, file 20-20127-FC. Today is the date set for a hearing on a motion to compel discovery. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
John Glazier on behalf of Mr. Crabtree, Your Honor.
Yep.
All right, Mr. Glazier, this is your motion. If you'd like to have any oral argument about it at this time, you can do that now.
Just, Your Honor, that I don't need to be too formal. I was just wondering if Jackie told me she had asked for the discovery, but I haven't gotten it yet.
I haven't received it yet. But John, you do realize that you have a duty to do your own discovery, right? Like, I'm not in possession of those documents. I requested them and I'm waiting on them. We got some of them in today, but we're still waiting on more. But you know, you have your own duty to do your own discovery, right?
So you're telling me you're not going to, the lab people you're going to call as witnesses, you're not going to get me the discovery?
That's not what I just said, John.
Okay, because you know what they're going to say to me. They're going to tell me to shove it.
All right, so
I guess, Your Honor, I would like to have her ordered to provide me with the items that I've requested. They're her expert witnesses. I should have their reports in complete detail anyway, and I don't. All I have is what they've sent her, some summary reports. These are things that their opinions are based upon, that their conclusions are based upon, and I don't have those. And I think that she should be ordered to provide those to me.
So can I be clear on what you're asking for? You're asking for like lab manuals? What are you asking for?
I told you the most important part of that, and I put it in the letter I sent to you, was number 1. I'll have to go back and look at it. The lab manuals and stuff like that are not nearly as important as item number 1 under my request for discovery.
Any reports they have in their possession as it relates specifically to this case, I have requested and they
All right,
have sent it
here's a complete.
or are sending it.
Here is what they have told me is the most important. They can't do theirs without it. A complete copy of laboratory case file indicating, but not limited to the chain of custody, laboratory notes, forms, electronograms, X gene mapper, IDX, ELEC tables, statistics, tech reviews and reports. Those they've indicated to me are absolutely necessary. And like I said, I sent it out a letter to you as soon as I got the request. Talked to my expert and told her what I needed. And she says the other stuff like copy of manual, number 2, 3, 4, 5, and 6 are not nearly as important as number 1. She cannot do her independent evaluation without those items listed in number 1. There's a 6-part discovery request. I think I included a cover letter when I sent it to you before stating that that was more important than anything else.
Okay, I understand that, and none of those items are in my possession.
Well, then, I don't know how, Your Honor, I guess I'd ask that she produce those. That's how her expert has come up with their report, their conclusions. And I can't review those without those things. Like my expert can't review those without those things. I guess if they're not going to
Did you send
provide
a subpoena to the lab?
I did not send a subpoena to the lab. The lab's not going to send me that stuff. They haven't sent it to you. You've requested it. And they haven't sent it to you. I'm in a bind, Judge. I have a trial in probably 10 weeks. And I have an expert that needs to get these items in order to make her evaluation. And if I don't get them, I'm going to be stuck in 10 weeks telling you, Judge, I can't do anything because I don't get the items from the lab.
All right, so yeah, what? So there's a discovery request filed December 16th, 2002, requesting this information. It is the plaintiff's, the people's expert, so that the information is more in their control than it is in the defendant's control. And so I think there is an obligation on the part of the people to get this information and provide it to the defendant. So, I mean, I guess I would just say I understand Ms. Wise is having difficulty getting that information from their expert, but I'm not going to make Mr. Glazer try this case without an opportunity to have this information and to have it analyzed by his own expert. So to the extent that your experts are not being responsive to you, they're jeopardizing the ability to try this case on the date that it's scheduled for, which is I don't think anything that anybody wants. So to the extent that I think Mr. Glazer at this point is entitled to an order to compel the discovery. So I'm going to enter an order compelling the discovery and requiring that it be provided to him within 14 days. And hopefully that will help Ms. Wise with her efforts to get that information from the lab. So that is that's the decision. I will issue an order consistent with that.
Okay. Is there any way we can set this for another review after 14 days? I understand Ms. Weiss is having trouble with her lab, and I'm sorry for that. But I want to keep track of this, Judge, because like I say, time is and at the last second, I don't want to come at the last second and say I don't have any of this. So maybe if we could set another hearing with 3 weeks from now or something.
I understand that this case has been pending for years and now it's an emergency. I mean, I'm trying, but I understand.
I understand. I'm not blaming you, Jackie. I know you're doing what you have to do. And I just have to keep track of it, Your Honor. If you don't want to set another date, I'll renotice it up if I don't get it in 14 days, however you want to do it.
All right, I would like to have a date just to check to check in and see where things stand. My Wednesdays over the next month are not good, so I will I'll identify a date. I'm free trials April. All right, how about March 8th at 8:15?
That'd be fine, Your Honor.
That works.
I think we're all set then. You can go ahead and log out.
All righty. Thank you, Your Honor. Thank you,
Thank
Jackie.
you. Thank you. Do you have anything else on the docket this morning, Your Honor? I don't think so, but
No, I think I'm all done.